Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be accomplishing three things. First of all, the duty of a director to disclose his age, the duty of a director to disclose whether or not he's a director in another company, as well as the appointment of director for life. So let's go straight to our lecture today. Now, when we read the provision of section 278, subsection 1 tells us that any person who is appointed or to his knowledge proposed to be appointed director of a public company and who is 70 or more years old shall disclose this fact to the members at the general meeting. It's a mandatory provision. It tells us that where you know that you are above the age of 70 and you are to be appointed a director in a public company, you must make sure that you disclose this. That is what this particular provision says. And also when we read subsection 2, it tells us that any person who is proposed to be appointed a director of a public company shall disclose any position he holds as a director in any other public company at the meeting in which he is proposed for appointment as a director. There are basically three things we need to know in this particular provision. That's section 278. If you know that you are above 70, or you know that you are a director in another public company, in those two instances, if you are to be appointed a director in a public company, you must make sure that you disclose those facts. The facts are, number one, that you are either above 70, or number two, that you hold a directorship position in another company. Do you understand? It is mandatory for you to do so, because the provision of subsection 3 says that any person who fails to disclose his age or multiple membership as required under this section shall, without prejudice to the provisions of section 307 sub 4 of this act, be liable to a penalty in such amount as the commission shall specify in its regulation. Which means that you are going to be penalized if you don't disclose the relevant fact, which means it is advisable for you to disclose it. And then we move on to the next provision, which is section 281 of Cama. And section 281 of Cama tells us that a person may be appointed as director for life, provided that he shall be removable under section 288 of the Act. So which means basically that nothing is going to stop a person who has been appointed as a director for life from being removable. It is mandatory. You shall be removable under section 288. You can't go and write it in your article, oh, this person is director for life, therefore it cannot be removed, or try to put it in entrenched provision under the memorandum and say yes, he is director for life and therefore cannot be removed. If you try to do that, then your memorandum or your article will become inconsistent with the provisions of the Cama, and that would mean that it will be null and void, because there is already a provision mandating. It is not a default provision that has an enabling provision in it. It is a mandatory provision that tells you that he shall be removable under 288. So therefore, there is nothing that you can do. So with this, we go to my next lecture as regards disqualification of certain person from directorship, and secondly, vacation of office of directors. See you in my next class.